following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the fundamentals and developments of contract law in Sri Lanka. Have there been significant updates to this area of the law? What does the future hold for entering into contracts? A very good evening and thank you for joining us yet again on another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, considering the fundamental nature of the topic that we're going to breach today, it's actually quite a surprise that we haven't done a separate episode completely focusing on just how important this part of the law is, and that's on the law of contracts, how exactly it functions and what we as laymen need to know in order to effectively use this law in order to prevent any sort of misalignments. To talk about this specific subjects and also the vital nature of contract law and how it impacts each and every one of us, we have someone that's not a new face on the show and has quite the level of expertise to bring us this topic here today, and that is Attorney at Law Dr. Udara Soysa. He is the lecturer in charge for public international law at the Bandaranaike Center for International Studies. So thank you very much, Doctor, for taking the time to come to the studio today and to explain this very vast topic in just, you know, this episode's timing, even though it's probably not going to be enough. A little bit of a breakdown on how exactly we're going to get through this topic. First, we'll be talking about the fundamentals and very basics. What is contract law and how it operates in the country? Next, we'll be talking about the current context relating to recent developments as well. And finally, we'll be talking about the future of contract law, specifically in relation to the advancement of technology and also the global impact. All right, well, without any further ado, let's get right into the nitty-gritties of this discussion. Doctor, thank you once again for joining us today. I'm sure, I mean, contract law is a very fundamental aspect of all laws, really, and it's important that we have a proper understanding of exactly how it functions in Sri Lanka specifically. So before we get into any of the specifics and any variances, can you please give us a basic introduction into what the essential elements are when it comes to entering into contract in Sri Lanka?
Wonderful. So in terms of contracts, Anuradha, you have to understand that contracts are part of everyday life. You have an employment contract with Derana. We go to shops and we buy goods based on contracts. So contracts are indeed a vast subject, and what you need to understand, it is you cannot exist without contracts. I'm sure even when we were in the Stone Age, though they were not exact legal systems as per contemporary standards, you had certain elements of contracts present even from that time. So when it comes to basic elements of contracts, you need to understand that there are two competing legal mechanisms. As you know, we have a mixed system between Roman, Dutch and English law. So let's focus on how as it applies to Sri Lanka in terms of basics of English law contracts, which applies largely here. That is not to negate the influence of Roman Dutch law, right? So there is offer, right? So you have offer, you have acceptance, and offer and acceptance together forms something called an agreement, right? So you need an agreement to start up. So I offer you perhaps a good for you to buy, you accept my terms, together we form an agreement. But remember, offer and acceptance does not in itself constitute a contract. You need to have other elements such as consideration that we'll go later. So you have offer, you have acceptance, and within the offer there are specific terms, and acceptance is the mirror image of the offer. For example, if I offer you my car for 10 million rupees, if you argue for this to be 8 million, right, or 5 million, this is not acceptance but rather a count offer. So when I give an offer, you can also give a count offer. Now what happens in a count offer, Anuradha, is offerer becomes an offeree, where offerer is the person who gives the offer, offer is a person who gives acceptance, right? So when it comes to a counter offer, it switches. So remember, there are certain terms you need to understand in terms of technicalities: offer, acceptance, counter offer, request for further information, invitation to treat, which is totally different from an offer. So these are various elements that we want to talk on today's show.
Exactly. Before we get into the specifics, like you said, consideration and of course any of the more complicated aspects of a contract, can we get to the two basic aspects which you just introduced to us, which is the offer and the acceptance? Can you explain to us how specifically in the digital age as today, how we see offer and acceptance treated under Sri Lankan law?
Wonderful. So let's take the basics. We, of course, when it comes to law, we define our terms either through a statutory definition or a common law or a case law base. So when it comes to offer, you can define it from one of the very famous British English cases of Storer versus Manchester City Council, right? As per Lord Denning's famous dictum, offer is an expression of willingness to enter into a contract based on certain terms with the understanding it is legally binding upon acceptance and thus no further negotiation. So the core element of the offer is, once I give you the offer, I as the offerer, whether it's in digital age or in normal standard life, you need to understand it is binding upon me. Now this becomes a bit complex as I'll explain to you, especially in the digital age and when we deal with information technology, right? But you need to understand the basics of offer before we go in there. Acceptance means the mirror image, right? So whatever the terms I offer to you, the fact that you agree with my terms, for example, as I gave with my early example, so there should be unqualified assent to my terms. What do you mean by unqualified? Unqualified here means nothing about qualification, it's about unchanged. So if I give a specific term, you need to agree to that term. That means there's no qualification, there's no changes in terms of acceptance. If you want to qualify any term, this now becomes a counter. So when we look at digital age, it's a bit complex because it is when you look at, for example, when you look at a display of goods when you go to a shop, that is not an offer. In fact, it is an invitation to treat, right? So you go to a shop and you see the prices. You are the one who gives the offer. The shopkeeper is the one who would actually accept your offer, not the other way around. A lot of people think that there are, when you go to shops, unless there are certain discounts, and then they actually it becomes like unilateral offer. That's a different story. In terms of digital age, somewhat similar. You have to construe whether it's an offer or whether it's an invitation to treat, etc., from the terms. So, for example, suppose you go to a website, right? It is a bit difficult for you to look at the web page and decide whether what is in front of you is a offer or invitation to treat. As you know, invitation to treat is not legally binding, like you see display of goods, etc. So you have to look at the specific terms and the context in which the digital information is laid out for you to decide whether it is an offer or something else which is not legally binding as invitation to treat. And you have to check based on the basic definition. Has this information sufficiently clear? Does the web page provided you with this information with the understanding it is legally binding upon your acceptance, and is this final? If there is any further negotiations that is to be done in terms of you having to discuss anything further in terms of price, in terms of any other mechanisms, then this will not be a offer. This would be invitation to treat. So Anuradhi, context is important, whether it's in the digital age or not, because from the context only you can construe and construct whether whatever the application at hand, whether it's an offer or invitation to treat. As I said, offer is legally binding, invitation to treat is not at all legally binding. Invitation to treat is just like an invitation for you to start negotiation or to conduct business. For example, I have a car and I'm interested in showing you the car. I'm like, hello Anuradi, I have a car. I would like to sell it to you. What do you think about this? This is the start of the negotiation. Whereas offer, where I offer you car to a certain price, I know that this is final. When you accept my terms, I have to actually sell it to you. I cannot go back on the promise. In fact, if I go back on the promise, you can sue for damages.
Exactly. I want to get into that, the penalties aspect as well. But before we do, sir, I wanted to ask you, now that's one end, the other side of the coin, which is the acceptance. Can you tell us what amounts to valid acceptance when it comes to a contract? Specifically now, of course, as you mentioned, we need to have discretion in the digital age as well. To understand what amounts as a valid acceptance could be a little bit complicated as well. If you could explain to us.
Wonderful. So one of the textbooks that you use, McHenry, describe acceptance supported by case law also as unqualified assent to the terms of the offer. So as I said earlier, for it to be an offer, the terms has to be clear. And for it to be acceptance, the terms has to be unqualifiedly accepted by the offeree. That means the person who accepts the offer. So a good example for you or a good illustration for you is you looking at yourself at the mirror. Right? So when you go into the mirror and you look at yourself, what you see here is a mirror image of yourself. You're not seeing, when you look at yourself in the mirror, you're not going to see me, Anurad. It's going to be your own image. So this is a great way of understanding. Right? This is where McHenry says, acceptance is the mirror image of the offer. So whatever is being offered, you have to accept the terms of its in entirety for you to be bound in terms of its acceptance. If you want to change anything, for example, suppose that you get a contract, you get a PDF of an employment contract, your next employment contract with Derana. Suppose if you want to change any terms that is given, and then that would not amount to you accepting. This would be certain. Then you're going to some other realms. In fact, it would not exactly be a counter offer in terms of employment context, because usually the employer is the one who gives the offer to the employee. So this would be a bit different. But if you go to, for example, to a car sale, and if they offer you a price, and if you want to negotiate it, and if you want to reduce the price, this would be a counter offer. In fact, you would be now the person who would actually make the offer, where the car sale would be in fact providing you with the acceptance. So sometimes this could go back and forth like a battle of the forms. But what you need to understand is, in terms of this digital age or not, you have to understand that you have to agree with everything. You cannot change anything else. You have to agree with every term simply put in the offer. If you want to change, or however, you have to understand there's something else called as request for further information. Sometimes you could be unclear about certain terms. So you might, suppose you have a digital contract, you can ask for further clarification. I do not understand these two terms. Can you explain to me? I'm selling this car, and you can ask this car whether, okay, does this car have, contain air conditioning? So this might not necessarily be a counter for this. This could be request for further information. That doesn't attack the original offer, because remember, counter offer would kill the original offer. So if I give you an offer, and if you give me a counter offer, now my offer is totally dead and gone. You killed it. You totally murdered my offer, right? However, when it comes to request for further information, my offer will still be there. You're just, prior to your acceptance, you want to get further clarifications, and later, once you clarify it, you can decide whether you want to give me a rejection of my offer, or you want to give me a counter offer. You want to accept the terms in its entirety. It sounds complex, but if you think about it slowly, this is quite simple, and it's very practical in terms of ordinary day-to-day life.
Exactly, the practical aspect is what we have to focus on as well. Specifically, I want to move on, so since we're running out of time in this segment, specifically when it comes to consideration in a contract, can you tell us exactly how and what contracts that appear without consideration, are they valid? How exactly is that area governed entirely?
Right. So McHenrick says that consideration is a badge of enforceability. You know, for example, when a police officer goes to enforce a law, he has to produce his identification, as we call, as a badge, right? So without this, the police officer will not be able to enforce his laws. So for you to enforce the contract, and I will explain to you what this enforcement is about. So we can have an agreement, right? Now, for example, you can have an agreement with your parents that if you pass certain exam, that they'll have to take you to New York. But is that enforceable by you, Anuradhi? Not. So where you need consideration to is actually to enforce the promise of the promiser. So as per the case of Curie versus Misa, consideration can be defined as detriment to one side and benefit to the other. For example, you lose your money, I get your money, and it has to come from you as a promisee, and then it comes back the other side as well. So I lose my product, you gain the product. So consideration is really important. Think of consideration like the backbone. Suppose I lose my backbone, I will not be able to sit in this chair and explain to you the theorization in terms of contract, because you need to have a backbone to sit. Same way, for a contract to stand, you need to have a consideration.
Exactly, the backbone of a contract, yes, as you have aptly mentioned it. I want to get into the specifics related to personal agreements that may not amount to a proper contract, specifically when it comes to the intention to create legal relations as well. But before we get into any of those further specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with Dr. Udara Soysa. We were just getting done talking about the basics of contracts and contract law in Sri Lanka, specifically the offer, acceptance and consideration aspects. As you mentioned aptly, sir, previously, it is the backbone of a contract, the consideration. Now, when it comes to forming a contract specifically, parties that are entering into contract also have specific criteria that they must meet. Specifically when it comes to relations, legal relations that have been created between, close family or friends, or maybe even those that have not done business with each other before. How exactly does the law really govern that area specifically?
Now, practically speaking, you need to understand this as a presumption. Now, domestic agreements are presumed not to be legally binding. I'll give you a practical example. Now, when it comes on, for example, my early example, your mother promised you, okay, when you get your next promotion at Derana, I'll take you to Paris. So your mother said it and you really believed it, so you work really hard here. You work amazingly hard here, but you work extra hard, the next step just for this trip, So now this could be a consideration, right? Because consideration is either price paid or forbearance suffered. So it's either you do something forbearance or you pay something. So this could amount. So there could be consideration because you're working hard on your job, could be consideration. But the crux of the matter here is the fact that this seems as a situation of a domestic agreements, as you see with the famous case of Balfour versus Balfour. Domestic agreements are presumed. Remember the key word, presumed, right? So domestic agreements are presumed not to be legally binding. So, for example, whatever the agreements that through your domestic circumstances that you make with your mother, father, often with husband and wife, right? this would not be presumed to be legally binding. Now we come to the topic of presumptions. What are presumptions? Well, presumptions are, like certain assumptions that you pre-assume, right? So basically that means if the presumptions are in my favor, so I have the upper hand in terms of the burden at law, where you have to rebut my presumption. Presumption doesn't mean like something written in like not in like tombs or monuments. Presumptions can always be rebutted. So how would that rebuttal comes here? For example, if you and your mother and your father and your brother, you are all directors of a company, this would not be your typical domestic contract, because in this situation this presumption can be rebutted by this commercial context. So in this commercial context, right, even domestic agreements or domestic relations can amount to be legally binding. So you have to understand, you cannot think, right, this is something that I always tell law students, you cannot memorize this theorization as, okay, domestic contracts are always not legal. No. Under certain circumstances. Now, for example, there are cases like merit versus merit, where even between husband and wife, if the parties are separated, if the agreement was made after the separation, now you can see often in our in the district court settings, practical, you have a lot of maintenance agreements which happens between separated parties to a marriage, of course highly legally binding. So do not under any circumstances memorize and theorize domestic contracts are always not legally binding. It is just a presumption. This presumption, like any presumption at law, can be rebutted by contrary evidence. If there is contrary evidence, that means if there are other evidence that can go against this presumption, practically you can rebut the presumption. And sometimes even between your family members, between you and your brother, you can have a legal relationship. In fact, practical life, you often, I've seen it even in situations when dealing with adults, even among siblings, I've seen often than not these relationships are legally, in fact, binding.
So it's not that specifically, contrary to popular belief among laymen as well, where domestic situations do not amount to having a valid contract creation. It can be between relations as well, family relations, given the context of the situation in which this kind of agreement can be reached. I want to talk about specifically when it comes to the failure to perform on a contract as well. When it comes to a breach of contracts, since we've already gotten through the entire life cycle, I'd say, a process of the contract, can you please walk us through what happens when a breach of contract occurs in Sri Lankan law, and also specifically a little bit of relation to the current context as well in the digital sphere?
Right, I'll come to that in 2 minutes. Before that, I want to cover something quickly. There are certain, before we come to breach, because this is connected to breach as well.
Right.
You need to understand, as a human being, you can get certain sicknesses, as you know, right? We had COVID epidemic, etc. Contracts too can get sick. That means what? There are certain phenomena called vitiating elements. For example, if there's misrepresentation, if there's undue influence, if there's duress, right? So in these situations, you would see, right, contract would either be void or voidable, which will reduce the ability to seek a remedy, right? So we will discuss, if we have time, quickly about these vitiating elements in a bit later. But now, since you asked, I will try to address the crux of your question about breach. So what do you mean a breach of a contract? It's almost as literal as it means. You break it, you breach it. So for example, if you and I have a contract, suppose that I want to sell you my phone, right, and I have given you an offer, you accept it, and then I later get a better offer, and I decided to provide it for the better offer. So now, what are your remedies? So what you need to understand, there are basically, we have certain, this is another topic, law and equity, but there are certain legal and equitable remedies that a party who suffers, right, or innocent party to a breach of a contract, innocent party is a party who did not breach, right, who dealt in this situation with good faith. So there's something called damages. So for example, you can seek damages. So talking about the entire damages, nominal damages, ordinary damages, so it's another one whole day of a discussion, but I will basically explain to you. This is what it literally means. So for whatever the losses that you suffered, there are various ways of quantifying damages, as we see with cases like Helios, Baxen Bell, etc. But damages are a legal remedy, and there are equitable remedy. Remember, equity, if you have dealt the situation with good faith, etc., equity too will afford you certain remedies such as injunctions, right, where you can in fact get an injunction to, right, stop something, right, maybe stop a sale, or specific performance. That means you can force me to act in a specific way. So these are specific performance and injunctions are equitable remedies, right, where you might not have a legal right to see it, but equity will offer you. But legally, damages would be a apt remedy in situations of breach of contracts.
Exactly, and on the relation to the breach of contracts as well, so can you walk us through what you previously mentioned, which was some of the elements that a contract can actually face, specifically when it comes to things like misrepresentation? I think it's better for us to get an understanding before we move forward into the digital context and whatnot.
So now you need to understand, right, when it comes to vitiating elements, you are able to perhaps end the contract and also at some situations seek damages as well. For example, if my phone is a Chinese phone, some kind of a Chinese phone, and I offer to you it as an iPhone, and clear you see there is something called a misrepresentation. Misrepresentation can be defined as an unambiguous statement of fact or law addressed to a party, right, and which induced that party to get into a contract. So I have induced you. So this is a material element here. So I have, in layman terms, I have fooled you, right? I have deceived you, right? I've fooled you to buy something. I've induced you to buy something that you didn't otherwise would have bought. So in this situation for misrepresentation, this is something that you call as a voidable situation, where innocent party has the right to, even if you want to keep, if you like the Chinese phone, you can perhaps keep the phone and get damages from me. Other things like undue influence. Suppose that I'm your lecturer or I'm your lawyer, and I have bought your lands which are worth a fortune for a very nominal price. So there you suffer something called a manifest disadvantage. In these circumstances also, you are able to, as the innocent party, you are able to ensure that this contract is void. So this is not ab initio void. This is not void from the inception. That means from the start, right? This doesn't kill the contract from its start, but you, as the party who suffered the losses due to undue influence, can seek to void the contract. However, you need to understand, in certain situations, if you can realize even with this undue influence situation, I've given you a really good price, or you don't want this land anymore, perhaps you can cover whatever the difference, right, and enforce the contract. There's something called mistake. There are two types of mistake: unilateral mistake and bilateral mistake. For example, if you think this is, the animal in front of us is a dog, and you think it's a dog, and I think it's a dog, but if it's not dog, it's some unknown animal, right? So this is a situation for bilateral mistake, where in a bilateral mistake, often the contract will be void. Not voidable, void, because you need to understand the concept of laissez-faire. That means there should be freedom of contract. That means our minds have to meet. When it comes to mistake, how mistake can vitiate or weaken, vitiate means weakening the contract, would be with the fact that we don't have a common understanding in terms of the contractual matter. So this could be bilateral or unilateral. There's another bilateral mistake called cross purposes. For example, suppose you want to, you want to get A. You want to buy A. I want to sell B, right? So the parties are at cross purposes, right? So there's no meetings of mind. So mistakes is another way of weakening contracts. So remember though, sometimes when it comes to unilateral mistakes, sometimes mistakes might not weaken as well. So this is a bit of a complex area of law when it comes to mistake. When compared to misrepresentation, there is of course the most famous things such as illegality. I pay you to kill somebody, right? So this would be not enforceable, right? For example, I cannot take, obviously common sense dictate that I paid you 10 lakhs to kill somebody and you don't kill this person. I cannot take you to court and say, okay, I'm rather fighting to kill. So this anything that is illegal against a public policy, void, cannot be enforced at court. So illegality, undue influence, and other thing is duress. If I put a gun at you and say, Anuradi, if you don't buy this car, I will shoot you and I kill you, or I will burn your cameras, or I will ruin your job, right? So this could be duress. So 3 types of duress. Duress to person, where I put a gun at you and threaten you, or I try to burn your house, and this is called duress to the goods, or I threaten to send some room and ruin your job. That will be economic duress. So these 3 aspects of duress, or these 3 categories of duress: economic duress, duress to person, duress to property, 2 can ensure a contract to be voidable. So you need to understand those. In the context, there are a lot of elements or a lot of vitiating, weakening elements that could weaken a contract.
Exactly. Thankfully, we were able to cover a little bit void and voidability, but I want to get into specifics as well, like limitation of liability and things like that. But before that, we do have to take a very short commercial break. Let's go in for a short commercial break. You're watching Law, Land and Liberty. We'll be right back in the final segment. Welcome back to Law, Land and Liberty. We're in our final segment. We're in conversation with Dr. Udara Soysa. So thank you very much for the previous 2 segments. I believe we were in the middle of talking about void and voidability and also terms when it comes to contracts. Can you please give us a little bit of an understanding on concepts like force majeure? Because I'm sure that the layman would really want to understand how exactly that plays a role in the performance of that contract.
Wonderful. Quick note on void and voidable contracts. Void contract is a contract that cannot be enforced under any circumstance. It's dead. Voidable means you can kill it, right? The innocent party has the ability to end it. Like I said, in terms of misrepresentation, if you are a victim of, if you're the innocent party of misrepresentation and you still like to enforce a contract, right? It's voidable, so you have the right to keep it. So now when it comes to force majeure, and now we are looking, I think we are mostly looking at in terms of frustration. So when it comes to frustration, again, frustration too is another vitiating element of a contract. What do you mean by frustration? For example, let's suppose I'm a singer. God's sake, I cannot sing, so I hope you don't ask me to sing, right? I cannot sing even to save my life. But
Never.
Suppose I'm a singer, and we have a contract where I come here to this wonderful, beautiful studio at Derana to perform live, and suddenly, while driving myself from Pitakotte to here at Derana, I lose my vocals. Now, this is something that myself foresaw. This is an unforeseeable reality. This is something that we call as an unforeseeable circumstances. So, what happens in terms of a frustrating situation, right? I mean, it frustrates the contract, and now it discharges, right? That means like a battery being discharged, the contract is now discharged. This means that you cannot enforce it, right? And there are certain other legal mechanisms where you can recover perhaps whatever the cost, and I can recover whatever my cost. So that's, that's something how we can equitably share the loss. So that's different. But the key in terms of frustration is whenever there is an unforeseeable situation, and you saw this a lot with COVID. I was dealing with some clients, building clients, for example, between suppose now one of my clients, construction company, I would name, they were supposed to finish an apartment building in Mount Lavinia area by 2023. But what happened? In 2020, COVID came, and you saw that there was it's impossible for you to get this construction material, etc., to the country during that time. Now this is something nobody foresaw COVID. This is something that called an unforeseeable situation. So sometimes, now now the 2022 date could be changed a bit forward, and you have to manage that situation. But now I'll give an example for a force majeure clause. Force majeure clause is where if you put a term in the contract saying, suppose you had some amazing foresight, and you put a term saying, in an event of a pandemic, there will be 6 additional months more, then this is something that you call as a force majeure clause. You have put a clause that would make a normally unforeseeable situation to be foreseen. Now, frustration would not apply, Anuradhi. Why? This could not be frustration. Why? This could not be frustration for the simple reason that there is a force majeure clause, and this force majeure clause have made the unforeseeable situation to be foreseen. Now this means the contract will not be discharged, and the force majeure clause will be at force, and this means the terms of the contracts would not be discharged and is bound by the parties.
Exactly. I want to get into the specifics related to that as well. We recently saw the budget being discussed and everything with the government's changes. So how exactly now, significant changes in tax law also coming in, how are, force majeure clauses or maybe hardship clauses, would they, if they were included, how drastically would it change the commercial contracts landscape in Sri Lanka?
Often you see, Anuradhi, in commercial, you have to understand commercial law to be almost like a child of contract law, or vice versa. You would see this, right? Often, in most commercial agreements, you have certain provisions for force majeure clauses. Suppose that, I'll give another good example. Now, maybe I'm a vehicle importer, and I have a contract to import, let's say, 100 vehicles, and the next budget will totally stop vehicles from imported into the country. So if there's a force majeure clause saying that in an event of a budget prohibition of certain imports, or of a policy, any kind of a policy document that stops these imports, then if this force majeure clause is there, then this force majeure clause will be enforced. Okay, in a situation where if this government stops the imports, perhaps I will keep 10% for my convenient cost, and I will refund you the 90%. So as a lawyer, it's better when parties are negotiating in commercial contract context these contracts. It's always better if you have this foresight to put these force majeure clauses. If you can think of these things could happen. Now we know COVID took a real huge toll on every industry, right? I mean, right? Construction took a massive hit. So force majeure clauses, I would say it's your friend. If you have a good legal team who could foresee like what could actually in fact happen in future, looking at what had happened in past, obviously, and you can put certain terms. So, okay, in an event of COVID, this is what's going to happen. In an event of tsunami, this is what's going to happen. In an event of total invasion by another country, this would happen. So these force majeure clauses would literally save your back. in situations, this would make the contract to function more smoothly, efficiently, and constructive to the goodness for both parties.
Exactly. Unfortunately, we're running out of time, sir. I want to ask you a very important question related to the current context, specifically when it comes to online transactions and e-commerce. How exactly can we expect the landscape for contract law to change moving forward, specifically when we're future focused? And do we see any large significant differences, or will we be able to stick to our basics and will it apply as effectively on the online sphere?
I think my concern in terms of online contracts is how exclusions and limitation clauses function. I see exclusion and limitation clauses as a means or tool in which both online and otherwise reduce the power of the weaker bargaining party. For example, if there is a contract where the digital contract says that we are not liable for any losses that happens because of our product. So if there's like, let's say, if there's a product being sold on Facebook Marketplace, or I don't want to name other platforms, if the platform or the seller is saying we are not liable, or we are only limiting our liability to, I don't know, 10,000 rupees. So in this situation, we have our sales of goods, unfair contract terms, and consumer rights legislation that governs right now. But what you need to understand is most of these have been made decades and decades earlier, with the exception of few new legal documents. In my opinion, there needs to be a large overhaul of legal reforms that should happen, reforming the operations of exclusion clauses, where you exclude the liability totally, right? It's like I'm selling you my phone and I'm saying I'm not liable for this phone not working or this phone damaging you. And interesting, those are written in very small prints also, right?
Fine print.
Yeah, fine prints, and or limitation liability, which often courts found more amicable, right, in situations. So legal reforms, in my opinion, should focus on both in online and offline context. Into modern context, have rights given to the consumer, to improve the rights given to the consumer also, because the law will treat consumer and a non-consumer or consumer business differently. Of course, consumers are given more rights, but then again, you see often people are not very happy with the actions and the reactions that you can take when it comes to consumer rights authorities. I myself, I would say, in terms, the laws should be strong, and the existing mechanisms like consumer authorities need to play vital additional role, proactive role, when it comes to protecting the consumer rights, and ensure that the consumers, also non-consumers, right, consumers are protected from unconscionable and oppressive contractual bargains.
Exactly. Unfortunately, even though there's quite a bit more that we wanted to get into relating to the current context and also the specifics related to contract law in Sri Lanka, our time here with you today, Doctor, ends right now. Thank you very much, Doctor, for taking the time to try and explain this very vast area. Even if we were only able to get to some of the shallow areas, I believe we gave a much more whole understanding on the entire subject. Thank you very much, Doctor.
Thank you so much.
All right, well, we leave you tonight with the words of Lord Denning. In contracts, you do not look into the actual intent of a man's mind. You look at what he said and did. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherthanenglish. Thank you very much for watching. Have a good night.